right, everyone. So my name is Nancy Fulton, and as everyone who has ever attended one of my events knows, we always start on time. I currently run events for writers, screenwriters, filmmakers, and other creative pros here in Los Angeles, and you can learn more about the events that I have coming up at nancyfultonmeetups.com. And tonight, I'm interviewing attorney Dinah Perez, who helps people sell film and television screenplays to Hollywood. So with that in mind, Dinah, do you want to spend just a few minutes talking about your background and your practice and the work you've done in the past helping people sell projects?
Yeah, well, I don't really want to spend a lot of time talking about my background because they can read about it online, and I think they're probably going to be more interested in content.
Mm-hmm.
I went to Loyola Law School. I've been in practice for 22. This is my 22nd year in practice, which is mind-blowing to me.
Mm-hmm.
And I would say I'm a solo practitioner. I would say that my business breaks down to probably 75% film and television and 25% music. And I'm mostly in film and television. Oddly enough, this is not by design, but by execution, because I mostly represent writers and writing teams. So I've had a lot of experience working with writers, and not only doing their deals, because doing a deal for a writer really is the last thing in the process of being a writer. So I work hand in hand with my clients, and sometimes when they start working on a project, the first thing that they do is that they call me if they have something that either requires that they partner up with someone, or if they're working on something that's not completely original to them. And so they call me because they want to make sure that they're going about everything correctly. If you're writing a screenplay or a pilot and a treatment for a television series, and you're working with somebody, you really need to stop before you start working, and you need to create a collaboration agreement between all the parties. And that's really important because it's funny because I just had this conversation with a new client today about how he had implied that he was going to be given a certain credit on a television series. And I said, that's the problem. In your head, you thought they were going to give you a supervising producer position, and in their heads, what they meant was a senior producer. And because you didn't come right out and say it, everybody continued forward with a mistaken assumption.
Mm-hmm.
And that's exactly what you want to avoid when you're collaborating with someone. The consequences can be dire if you start working with somebody and you don't have a written agreement and everything falls apart, because copyright is automatic, and copyright attaches as you create content. And so both parties will equally own whatever is created unless there's an agreement that says otherwise. And in truth, most collaboration agreements are 50-50. But what the collaboration agreement will do is address the issue of what happens if one of you decides you don't want to finish it.
Mm-hmm.
If you have a falling out, who gets it? How does the writer who falls out get compensated for any of the work that writer did? Does that writer get compensated at all? And if you're working together, it spells out certain deal terms, like who's going to be pitching this property? Who decides on the sale? There are going to be creative issues, and there are going to be business issues that come up in terms of the collaboration. And if you can't agree on an outcome, who has the final decision? So having a collaboration agreement forces everybody to really think about their relationship and how that relationship is going to work out under good circumstances and under bad circumstances, so that the worst thing that could possibly happen doesn't happen. It doesn't get finished and the whole thing gets shelved.
You mentioned in the notes that you sent over that you can put triggers into the document which indicate things like, if we receive a reasonable offer for our project, then it can't be. We both agree that we will not decline it. How do you determine exactly what kind of what represents a reasonable offer in a context where you have two or more writers who may have very different ideas of what represents reasonable. I mean, do you have to decide that up front? Because for a lot of people, that might make it so the deal doesn't go forward at all.
What I do is I either say an offer that's industry standard, an offer that's WGA minimum. We will come up, depending on who the writers are,
Mm-hmm.
then we will know what that offer needs to be.
Mm-hmm.
If we have neophyte writers, and none of them are WGA minimum, we can say an offer that's at least 75% of WGA minimum.
It is really common. In fact, I think it's actually the rule that when you have two collaborating writers, you will have, one of them will fall out over the course of the process. And then how do you define what percentage, how is it, is there a fair way, or have you come up with a way to define how
it's
the
really,
second
quite
writer
honestly,
gets paid?
it's going to depend on at what point that collaborator falls out.
Mm-hmm.
If the collaborator falls out 3/4 of the way in, then, they should get pro rata their share of the money, but as it's represented in the final draft of whatever gets made.
Really?
So if at the end of the day, because they dropped out and they weren't involved, like let's say they dropped out while they were writing it together, but not before it went through development, right? Mm-hmm. With a network, then it would be, hey, you will get a pro rata percentage based on how much of your content ended up in the final, and in no case will you get less, let's say, than 10%, kind of a thing. Sense. So, and I also have in here what happens if somebody dies, mm-hmm. and if one of them dies, it would be the same formula as if they had dropped out, except that the money would go to the estate.
Isn't it true that if at least in the state of California, if a writer is married and he writes a project, then his spouse is actually a co-owner of that project?
Well, it's not just California; it's as per copyright law, pretty much.
Really?
Because in most states, you do have either community property or tenancy common. Mm-hmm. So whatever intellectual property gets created, it's considered part of the marital assets.
Mm-hmm. So that means if my co-writer gets divorced from his wife and it's a big dispute, and it means
she gets half of it.
Is that always the case, or is it the case only if our written agreement between the two of us specifies that?
No.
That
no. You have to look at it like community property. It's not worth putting that much effort into talking about it because mm-hmm. there are more important issues to discuss during our call, and the reality is that this is really only going to happen if somebody's died, and at that point, it's going to be, if there's a spouse, the spouse will get half of it, and the other half will go to whomever they designated in their will. It could mm-hmm. be the spouse, it could be somebody else.
Mm-hmm. Well, I think the only time it gets to be interesting is when you have just because copyright law lasts for so long, right? Isn't it 75 years plus the life of the author? Mm-hmm. So, it's like pretty much it's always going to be, being inherited by heirs.
Right. So the other thing I'd like to touch on, and then we'll move into agents mm-hmm. and shopping and deal making, okay. is life stories. Mm-hmm. A life story is happens when you have a writer that wants to write a screenplay or a series about a person that's either living or a person that lived and died. Mm-hmm. And it's important for people to understand that there are certain rights that people have mm-hmm. that we can't take away from them. And you can't just go and write a life story based on somebody just because you want to. So there are two rights that everybody has. One of them is the right of privacy, and the other one is the right of publicity. So the right of privacy allows us to keep private our private lives. But the interesting about the right of privacy is that it's on a spectrum. You have people that have an absolute right of privacy, like the neighbor who lives across the street from you who was a Vietnam vet and nobody knows who he is except the people in his immediate life. Mm-hmm. And then you have people like the Kardashians, which are on the other end of the spectrum. And in the middle of the spectrum, you'll have people who used to be famous, people who are less famous than the Kardashians, because the Kardashians put their whole lives out there for people to know about. But you've got, in the middle somewhere, you've got people who are less inclined to be public about their private lives. And you've got criminals who maybe were at one time what I call celebrity criminals, like Jodi Arias, for example, or Charles Manson, people who were all over the news, O.J. Simpson. And then you've got people who were celebrity criminals at one point in their lives, and like 30 years later, somebody all of a sudden decides they're going to write something about them, but they've recaptured their privacy. So when you have somebody like the Kardashians, they have much, much less right of privacy than the neighbor who lives across the street from you. You really need to get a life story agreement if you have somebody that has an absolute right of privacy. And if you're writing about somebody who, let's say, is a politician, you can disclose things that are known about them, but you can't disclose things that are really private. My rule of thumb, because pretty much any insurance company is going to require it anyway, is to get a life story agreement from people that gives you the right to write the screenplay and to air it. Now, regarding the right of privacy, in many cases it dies with the person.
Really?
And it depends where they died. So, state of California will treat it differently than the state of New York. State of Washington treats it differently than the state of New York.
If somebody's living in the state of California, if they're resident in the state of California and then they die,
and they die here, they get the right of privacy. Then they have a certain
set of rights. But if they were living in the state of New York and they died, they have a different set of rights.
Yeah.
Is it different if they're actually overseas, like somebody who lived in the UK or in Europe?
Yeah, every place is different. So if you want to, let's say that you want to write a life story about someone. One of the questions, if the person's not living anymore, one of the questions you have to ask is, where did the person die? And then you need to do research to find out, okay, in that jurisdiction, does that person have a right of privacy after death?
Is it where they actually died, or is it where they were resident when they died?
You have to look it up, but in most cases, it is where they died. And then, the other thing that you have to balance against that is the right of publicity. Because in most cases, the right of publicity does survive death. But you still have to check it out just to be sure in the jurisdiction where the person died. But, for example, here in California, the right of publicity survives death. And the right of publicity allows you to commercially exploit the name and likeness and image of a dead person. So if I wanted to sell Marilyn Monroe memorabilia in California, I couldn't sell it because she gave those rights to somebody, and that person is collecting revenues on that. So the state of California, because we have so many celebrities here, is very, very willing to give the estates of celebrities the right to benefit from
the commercial use of their work.
Yeah, after death.
But is it so? Is it the case that if somebody is doing a docudrama based upon Marilyn's life story, and their source is all newspapers and so forth, or interviews with people, do they need to have clear a deal with the estate in order to be able to write about her?
Yes, because there are two rights. So you can probably get away with it in terms of the right of privacy, but you have the right of publicity that you have to deal with. And in let's talk about the realities. Because we've got all these rules that say you can do this, you can't do that, you can do this. But in reality, at some point in time, if you find a distributor, you're going to have to satisfy the distributor. And one of the things that you'll have to do to satisfy the distributor is get E&O insurance, errors and omissions insurance. So either the distributor or the errors and omissions carrier is going to require that you have written agreements, because the distributor and the insurance company want to avoid a lawsuit. Okay? So those are a couple of the big issues. The last issue that has to do with writing a screenplay or a pilot has to do with source material.
Mhm.
If you are using a book or a magazine article or anything that you did not create as your source material for what you're writing, let's say that you decide you want to adapt a novel or a play. If that material is not in the public domain, then you need to get permission. You need to actually enter into an option purchase agreement with the owner of that source material. And by public domain, I mean it no longer has a valid copyright. I know a lot of people like to throw around the words, well, it's fair use. Yeah, fair use is a very limited exception to copyright infringement, and it's generally not going to be fair use unless you're writing a documentary. You have to go through the trouble of acquiring the rights. Do not write it until you have the rights tied up, because first of all, it's copyright infringement for you to create something from material that isn't yours. But secondly, who wants to waste their time?
So
right?
if somebody wants to do takes the legend of Paul Bunyan and wants to turn it into some sort of animated movie, that's one thing. Paul Bunyan's a legend; it's been around for a long time. Or the legend of Bigfoot. But if they want to take something like The Perfect Storm, where that guy died, even though it's in the common, even though it's in the common market, even though everybody knows the story, that's something that you would need to get. If you wanted to do something based upon a book called The Perfect Storm, you'd actually have to get those rights.
Right, but let's go back to your Paul Bunyan example, because that's a more interesting one. Okay, because there was actually a very similar situation in terms of somebody, college professor, had written a book based on the life of Sally Hemings. Sally Hemings was Thomas Jefferson's slave mistress, and he had children with her. So another woman came along later, and she wrote what was supposedly a novel about Sally Hemings. And that woman was sued for copyright infringement by the professor, and she lost because she had used the professor's book. And so you have to be very careful when you're using a book about a historical figure, because sometimes an author will have research, and they'll have point A, and they'll have point B, and they'll have point E. Right? And how do they tie point A and point B to point E? They can come up with their own theories for point C and D. And you need to, if you're going to use source material of a historical nature, you need to know what was the author's theories and what was based in historical fact.
Right.
You can use historical fact because you cannot copyright history, but you have to be careful not to be using the theoretical.
If I want to make something that's based upon something that happened in court, that
you can
happened
use that
recently,
as long as it's part of the transcript.
So the court transcripts are okay, which is one of the reasons I guess people do so many crime-based stories, because they can it's something, or crime docudramas, because they can actually they can reenact those things, correct?
Yes.
So, like that's why they have courtroom dramas, is because you can reenact those things, and that doesn't violate the portrayal. If I have somebody sitting up on a stand portraying a witness that actually appeared, I'm not violating that witness's right of privacy?
Well, they might change. First of all, they might change the witness's name. They might get a release from the witness. It depends. It depends how the production is doing it. And some productions self-insure, like big studios like Disney and places like that. They self-insure. So there's certain leeway that they have, and certain decisions that they might make that other people may not.
And so do you think that every project, fiction or nonfiction, needs to have errors and omissions insurance?
Well, it's not that I think it; it's required.
Right, in order for the film, or actually for the screenplay.
Well, the screenplay gets incorporated into the film. So you're not going to buy the errors and omissions insurance until you have distribution. Because you don't need it unless it's being distributed. And so as a writer, that's not something you have to worry about. That's something that the producer will have to worry about. But the producer will be worried that you have all your documents in order. Right.
So you're saying that even though it's not something that the writer's going to have to pay for, it's something they have to be conscious of when they're writing, that they may that at some point their script will have to be turned into a movie, and it'll have to be insured. And so people are going to be asking them hard questions like, okay, you did a true life story about Abraham Lincoln. Where did you come up with this information that's unique?
And here's the thing. if a writer engages an attorney up front, if they're going to be doing any of this, they don't have to be worried about, oh my God, I didn't think of this, oh my God, I didn't think of that, because the attorney will think about all that for you. And the attorney will help you tie everything up. And here's the thing, if you can't tie up rights that you need, then you don't write the screenplay. You don't waste your time.
That makes a really good. It's a really good advice. Do you think it's one of the things you mentioned also I wanted to talk about? You talk about a right of privacy, and you mentioned that there's the concept of libel and defamation, which is when you actually somebody might have been a historical figure or might have been involved in a case. So
you can't defame a historical figure.
Right. But let's say that I buy the life rights of the wife of a famous person, right? And do I have to buy the life rights of 4 or 5 people around that person?
It depends.
What happens if they say, well, you took her story and you made it sound like you bought the rights from one person and you're representing that as being true, but it depicts me and that's not actually what happened.
You can't knowingly defame people, and not everybody's going to be thrilled with what you do, but generally what happens is that when you're doing a life story situation, you try to acquire releases from everybody who's going to be important to the story.
Cool. And life rights is a release, correct? It's a release or a contract, isn't it?
It's a contract. The result will be a release.
Right. It's basically saying I'm giving you my story and I'm not going to sue you if you actually produce it.
Right. Okay, so I just wanted to go over that because I wanted people to see how it is that you could end up needing an attorney right up front and how important it is, because here's the thing. If you don't get all of those pieces in the puzzle correct, you will not be able to sell your screenplay. And that's why I felt like it was important to talk about that and get it out of the way.
I think it's good.
Not having the rights tied up, whatever they are, will keep you from being able to sell the screenplay. Make sure that it's done properly so that you don't have to worry about that. Once you've got those rights tied up, you don't have to think about them again. So you want to go out and you want to shop your screenplay. Well, my advice to you is before you do anything is that you register a copyright. Go ahead and register the copyright with the U.S. Copyright Office. You go to copyright.gov. It'll cost you $35. And you pay for it and you upload it. If for some reason you can't figure out how to do the application, you can always have your attorney do it for you. But you really should register that copyright before you start shopping it. Now, I know that a lot of people, there seems to be a lot of confusion among writers between a copyright registration and a WGA registration. Copyright is protection that you have by law. And although copyright is automatic, you won't be able to sue unless you've registered the copyright. So it's best to just spend that $35 and register it before you start shopping it.
Is it the case that you can't sue because it's too difficult to prove that you actually own you're saying it's very expensive to prove that you own the intellectual property. So even though I get a copyright the second that I create something, if I send my screenplay around and somebody else gets to the Copyright Office with it before me, whenever I go to trial, I'm going to have to prove somehow that I wrote this thing even though I didn't register it and they did.
Right. Yeah. But the bottom line is the reason really doesn't matter. All that matters is the formality. And formally, you are required to register a copyright if you want to litigate.
Okay.
Back to the confusion between the copyright and the WGA registration. The WGA provides no protection whatsoever. They are useful if you have something that you cannot copyright. For example, copyright only protects the expression of an idea, not an idea. So if you have a treatment, you can register the copyright for that treatment. But if all you have are 2 or 3 sentences, that's not really the expression of an idea. That's just the idea that you've written down. So if you only have an idea, go ahead and register it with the WGA. Because even though the WGA does not provide you with protection, it will allow you to park your idea somewhere that shows that it existed as of a certain date.
Mhm.
So that if you're out there and you're pitching and you have an idea theft issue, well, you couldn't register the copyright, but hey, I registered the idea with the WGA. Look at the date on the registration. And I went and I pitched it to you 3 weeks later, so it already existed when you said it didn't.
I see.
So, okay, so just remember anything that you've written, like a treatment or even a synopsis or a teleplay or a screenplay, you can go ahead and register a copyright. It'll be valid. But if you have what is essentially just an idea, go do the WGA registration.
Very
And so once you've done that, then you can start shopping your screenplay and you can start pitching it. Now, you have to be really careful when you pitch because you don't want to essentially give the person that you're pitching this to a gift. And when I say by a gift, I mean you meet somebody at a party or at a restaurant, and right away you start blurting out your idea to them because you're so excited that you've met somebody who could maybe say yes to you. The problem is that if you blurt out the idea for your screenplay, you've lost it. You've given it to the person who listened to it. Because you have to give people the opportunity to say, you know what, I have a lot of projects in development. I don't want to hear your idea. I don't want to be put in a position where I'm developing something similar and now all of a sudden you've pitched this to me and now I've got a problem, right?
Mhm.
So you have to give people the opportunity to say no. So my suggestion is that you only pitch in formal settings. Make an appointment to go in and pitch. Make an appointment to pitch it on the phone. Make an appointment to pitch it in person. Keep a paper trail, so when you make the appointment, follow it up with an email that says, hey, it's great. It was great talking with you. I look forward to coming to your office to pitch, blah, blah, blah. And then when you leave, make sure that you follow that up with an email thanking them for the meeting and the purpose of the meeting. Because now you have a paper trail that shows that you were actually in there to pitch. The reason that's so important is that you don't have a written contract to sell your content at that point in time. But you do have what's known as an implied contract. When you go meet with somebody and you go and you pitch your property to them, it is implied that you're there to sell it. They don't have the right to go ahead and steal it from you saying, well, it was just an idea. He just told me his idea. No, he was in your office pitching to you because he wanted to sell it and be paid for it.
Mhm.
Okay? So that's why that's really important. Sometimes even in an office setting, you can set up an oral agreement where, there's a conversation about what happens if you make it. I want to be paid, WGA minimum, and I want a credit, blah blah blah. And if that happens, you can reference that in your email. But you might want to run that email by your attorney before you send it. So that's another way that you protect your screenplay when you're pitching it, is no blurt outs, which is what that's known as, a blurt out. And then lastly, submission releases, which I think that every writer who has written anything and shopped it at least once knows what a submission release is. And I would say don't sign it without consulting with an attorney, because the submission release essentially throws away the baby with the bathwater. It gives the person that you're signing the submission release for essentially permission to steal your idea and to take all of the elements out of your screenplay that are not copyrightable. And in some cases, it even gives them the right to go ahead and make the movie and then pay you later whatever they feel like paying you. So I always suggest to writers that if a company tells them that they can't take a submission without a submission release, to find out if they can make an attorney submission. And just yesterday, I made an attorney submission for someone, and that just entails, rather than the screenplay coming from the writer, it comes from the attorney. And very often, the company will take the submission coming from an entertainment attorney and not require the submission release, which I prefer to do without.
That's smart.
Okay, so let's say that everything goes really well, and the company wants to go ahead and they want to option your material. It's Well, let me put it to you this way. In my 22 years in practice, I have never had a company offer to buy a project right from the get-go, because companies don't want to spend the money to buy a screenplay until they know for sure that they're making it. So what they want to do is option it, which is essentially the equivalent of renting it for a while. And a lot of producers try to get away with doing a free option.
Mm-hmm.
I try to keep my writers from doing free options for a couple of reasons. The first one being is that you're going to have to pay me, because I don't work for free. Attorneys don't work for free. And attorneys are not going to work on a percentage basis on a free option. Just not going to happen. So if you're going to be out of pocket on legal fees, then you need to be paid an option fee. It can be, if the producer doesn't have a deal anywhere and they don't have, they haven't had a lot of experience and they don't have a big track record, that maybe they don't have a lot of money. But you know what? If they can't come up with $2,000, then they don't belong in the business of producing.
I think that's true.
And if it's a WGA writer, the WGA does require 10% of the purchase price as the option fee. And the purchase price, the way that the WGA figures it out, is based on minimum. I know that a writer might have a quote of $1 million, but that's not Writers Guild minimum. It's only 10% of Writers Guild minimum. So now that writer who has $1 million fee may require a hell of a much bigger option fee than WGA minimum, but technically WGA members, they can option for 10% of the purchase price. Okay. And then, how much somebody gets paid is really going to depend on what's being offered and whether the writer has a track record, whether the production company has a track record. I saw a really odd deal yesterday where they were offering to pay the writer $50,000 for the purchase price, but then they wanted to do a production bonus that was based on the budget with a floor and a ceiling. And I didn't like that, and I rewrote the whole thing, because I don't want a production company to exercise the option for $50,000 and then never get the movie made. Because now you've essentially sold your screenplay for $50,000.
Yeah.
So the way that I normally structure them, if we don't know what the budget is going in, I structure it as a percentage of the budget, which is, for me, it's 2.5% of the budget with a floor and a ceiling. So in this case, it was $100,000 and $300,000. I also include in these contracts, if it goes to a studio or a mini major, that they get at least half of the setup fee, which is the fee that the studio will pay a producer for bringing a project over. I want my client to get a box office bonus. Very often, you've got a client who is not being paid a lot of money up front because it's a lower budget project, for example. So if the film ends up being theatrically released, that's a great example, Paranormal Activity, and it does really, really well at the box office, then why shouldn't the writer benefit from it, right? So I put in bonuses along the way. So, up to $100 million box office, my client might get an extra $25,000 for every $10 million bump above $50 million. And they get to make a lot more money. I put in a nomination and an award bonus.
One of the things that you'd mentioned in your notes, which I think we really should touch on at this point, because I think a lot of times, a lot of people that are involved in my groups are sort of first breaking in, and they don't know if it's possible for them to pitch projects directly to producers or to studios, or if they should be working with agents or managers. And a lot of times they don't know which is better for them.
Before we get there, let me finish the deal terms, okay?
Cool.
Okay. So, and then one of the other things that I know a lot of writers really are interested in is percentage of net profits. And I will tell you that in my experience, 99% of films never hit net profits.
I agree.
So I prefer to fight to get my client as much money as possible up front. And I mean, the net profits are pretty standard, but just don't ever expect to get anything. And lastly, it's the credit, which is really important to my clients. Today, I was negotiating a deal where this company decided off the bat they want to have another writer come in and rewrite my client right away because they want a writer with a marquee name. Well, writers don't have marquee names. Most people don't remember who was the writer of a movie. You know, you might remember it if you're in the film business, but not otherwise. So that, to me, is not an excuse for bringing in a whole new writer, because it can diminish my writer's credit. And so even though my writer may not be a WGA member, I always put in my contracts that credit will be determined using the WGA's rules for credit determination, because I want to make sure that I protect my writer's credit as much as possible, because I know that that can be parlayed into the next project, but they have to get that credit. Okay. So, and then there are other things in the deal that you know, I will negotiate for my client, and when I work with somebody, I do go over everything with them. So in terms of agents and managers, it is almost impossible for a writer who is unproduced to get an agent or manager right up front, unless you get a personal introduction to one through a friend, for example, or you happen to meet one at a party or something where you're talking to them and they're willing to read your material. It's going to be very difficult because both writers and agents, they're really busy. And managers and agents are really busy. And agents are really focused on money. They're not really into nurturing talent. The agents are not what they were 30 years ago. They don't have time to be nurturing talent. They've got a lot of talent that they represent. And before they go and they look to sell the screenplay of some guy who's never been produced, they're going to go sell the screenplay of somebody who has been, that they know is pretty much a sure thing. Managers will take more time to nurture talent, because a manager is looking at the long-term viability of a client over an agent. But even then, they don't want to teach a writer how to write. They don't want to sit there and develop the writer's screenplay. You pretty much have to have your screenplay finished, and I mean really finished, before you can even show it to a literary manager. And my advice to most writers is, don't let that stop you, because you have to open the door somehow. And if that means that you have to go out and pitch, then you go out and pitch, which means that you need to know what a log line is. And you need to have a 3-minute pitch that you can share with a producer or a development person when you call on the phone, because very often they won't schedule a pitch meeting to meet with you face-to-face. They don't want to waste that time. But if you get them on the phone and you get to pitch them on the phone, you better be ready, because you don't want to lose your opportunity. Because I can't tell you how many times people call me and I say to them, what's the log line? And they don't know what I'm talking about. And I know that that's somebody who's just not going to get their screenplay sold.
So when you and I were speaking yesterday, I mentioned the fact that the LA Times had just declared the spec script dead. And you said, yeah, you know, it's much easier to sell something if you've got a book, if it's based on a book, or you've written a book and then you're writing the screenplay. You've written the you sell the rights to the book, and then you from that you get a chance to write a screenplay. Can you sort of talk for a few minutes about that?
Yeah, well, the thing with the spec script, and I'm talking about studio deals here, because you might find an independent producer who's willing to do a little $1 million project with you. But the issue with the studios is that movies have become so expensive. They're almost cost prohibitive in many ways, right? And so they have to really hedge their bets. And they might buy a spec script from Guillermo del Toro or Chris Nolan, or somebody at that level who has that track record. But for somebody who's an unknown quantity, they don't want a spec script from you, because they're spending too much money. And they've had too many movies that they thought would do well flop at the box office. So they hedge their bets by making a movie that is based on material that's going to bring an audience right away. So if they are making a movie that is based on a best-selling novel, if they're making a movie that's based on a graphic novel, or a movie that's based on a video game, or a movie based on a famous person, they know that there are a certain number of people that are going to show up at the box office on that very first weekend because they bought the book, or they read about the story online, or because that person follows that graphic novel, and that that comic book is really popular, and all the young kids go to Comic-Con and they're crazy about it. So in all likelihood, that's what's going to happen. So if you're trying to break into the industry, if you want to write something that's bigger than a little $1 million project, I recommend that you look for material. Go look for a magazine article that was in Rolling Stone or in Forbes or something, a big publication. Go find a novel, and go find a play that was on Broadway. Maybe you can find a graphic novel that's done really well that's not owned by Marvel Studios, right? Because you won't get anything by Marvel. But try to acquire underlying content that is going to be of value to the studio.
Is that true for television shows as well? Like if somebody's writing spec TV pilots, or
television is a whole other breed, because television is so difficult to break into. It's harder to break into than film.
Is it really?
Oh yeah, because there are only so many hours available for television. On a network. HBO only has so many hours, and ABC only has so many hours, number one. Number two, most of the production companies, if not all of the production companies that are producing for television, they're all run by writers.
Really?
Television is a writer's medium. Film is a director's medium. Television is a writer's medium. And so most of those producers are developing their own ideas. They're not really interested in somebody else's ideas. So you kind of have to work, whereas you could write a screenplay and decide that you're going to write $1 million screenplay and you're going to go out and raise money and you can get it made. You can't do that with television.
That makes sense.
So Chuck Lorre is probably not going to be interested in any spec script that you write for a series. So your best shot to get into a series and to develop that career where you can eventually be your own showrunner is to sell a teleplay for one episode. You write a spec then, and you shop it around, and you hope that they'll hire you to write one episode. But to get a TV series, to land a TV series from the get-go, highly unlikely.
I guess I think some people have managed to do it because they've produced an independent film that did extremely well, and then somehow
they cross over.
They cross over.
They cross over. But in general, if you're starting out in television, you're going to be working your way up the ladder.
Right, which means you're going to be starting out as a staff writer, and then getting a staff writer job or a PA job, and then moving up through the writers
writer's assistant. You sell one episode. Maybe once you sell the one episode, maybe they end up putting you on staff somewhere. But it's a longer road to hoe if you want to go into television directly.
Right. So you've given us a lot of good ideas in terms of the fact that people should look for underlying properties that make their project more valuable than just a spec screenplay that they came up with.
Right. Now, the one thing that everybody needs to be aware of is, just like you expect a producer to pay you an option fee for your screenplay, the owner of that underlying property is going to expect an option fee.
Right. So it's an investment you'll have to make.
Right. That's something, and it's interesting because the agreement that my writer clients enter into on behalf of their screenplays is the same agreement that the owner of a novel will enter into. There's going to be an option fee. There's going to be a purchase price. There's going to be profit participation.
That's very interesting. So a lot of times, people who manage to get to know producers and who get an opportunity to write for them find themselves facing a work-for-hire agreement. Can you talk a little bit about a work-for-hire agreement and how that's different from selling a spec screenplay or selling a screenplay to somebody?
Well, when you do an option purchase agreement, if the producer can't raise the money, the option will expire, and you will keep the option money, and the screenplay comes back to you. The rights to the screenplay revert back to you. When you do a work-for-hire agreement, you're essentially entering into a contract with the producer where the producer is saying to you, hey, I am going to pay you to write a screenplay, either the one that you pitched to me or the one that's based on my idea, doesn't matter. Excuse me, but I'm going to hire you to write this for me, and this is what I'm going to pay you, and I'm going to own it from day one.
Mhm.
They will own it, and it's how the deal gets done depends. Sometimes they will pay you a flat fee to do all the steps from, treatment and beat outline to final draft. Or what I usually do when I structure these for my producer clients is I do it as a step deal. So this is what we'll pay you to write the treatment. Well, I'll pay you to write the first draft, the second draft, the polish, whatever. And if at any point in time my client, the producer, feels like the writer's not delivering, they don't have to proceed to the next step. But my client, the producer, gets to own everything. And what I put in agreements when I represent the writers is I put in a turnaround clause, which essentially says, and I put this in the option purchase agreement as well in case the movie gets purchased but never gets made, is that if the producer doesn't get it made within 5 years, I give my client the right to buy it back.
That's cool.
So if my client wants to buy it back in 5 years, they'll have it. Usually the industry standard is an 18-month period, an 18-month window, when they can pay back the producer the money the producer spent developing the screenplay and then get it back. Now, usually the writer is not out of pocket on this. What happens is, for example, I have a client that has had the property that was at Paramount. It was at CBS. It was at Universal. It's been everywhere. And there is $20 million against this property because they had some really high-powered writers working on them, writers that got like $1 million fee. And so what will happen is, let's say that Warner Brothers decided that, yes, I'm really interested in this property. Well, Warner Brothers will then sign an agreement with everybody that has a turnaround right with this saying, if we make the movie, we'll pay you back. And so you don't have to be out of pocket, but you do have to find a producer who's willing to pay the turnaround fee when they make the movie.
That makes sense. Because basically it makes it so the other guy is whole and the project can go forward without.
Right, and sometimes, for example, you might end up with somebody like, let's say that Universal paid the lion's share of writers' fees. Let's say that of the $20 million, let's say that Universal paid $15 million. They might say, okay, well, yeah, we want our money back, but we also want the right to distribute the film in the U.S.
That makes total sense.
Yeah. So, but the work for hire. Look, as a writer, you really want to become really good at rewriting. My friend Ray Wagner, who produced Turner and Hooch and is no longer with us, always said to me, the art of writing is rewriting. He was a man who had been president of production at MGM. He had developed The Goodbye Girl and The Champ and Fame and Legends of the Fall and The Lion in the Winter, and he really knew about development. And we talked many times about writers and writers that both he and I had worked with who made their lives really difficult because they were not really willing to rewrite. Some people just don't have that talent, and I get that. But there are other writers, and I've represented some of them, who refused to deliver the rewrite that the producer wanted. And the thing is that once somebody has an option on your property, or once somebody hires you under a work-for-hire agreement, They have the right to replace you.
Mhm.
Why would you give somebody the opportunity to replace you if that wasn't necessary?
Mhm.
And I get that some writers are not really great at rewriting. That's fine. But if you can really rewrite your own content, you're going to more likely stay involved in your project up until the end and get the sole credit.
Mhm.
Which makes sense because there's more money involved, there are more bonuses involved, there's more of everything if you get the sole credit, in addition to, that really boosting your career. And lastly, if you are really good at rewriting, guess what's going to happen? People are going to hire you to come in and doctor up scripts of writers who can't rewrite.
Mhm.
So that in between you selling your own projects, you have a way to make a living as a writer.
That's true. I mean, I think it is a talent for rewriting. I mean, I think there's a lot of people that people that choose to be writers because they enjoy writing. And so what happens is, they find everybody has their Achilles heel, and some people really do not like to rewrite things. So they're really good at doing the first draft and the second draft, but after that they're done with that project, and they don't care if there's going to be a second or a third or a 15th writer, because if they have to spend one more minute working on it, they're going to go crazy. So, and some of them I've met are really brilliant writers. They're really amazing. I love their first draft. I like their first draft better than their second draft, because you can tell that they've lost interest. So, it is an art to be able to collaborate with other people in the process of creating a film that, based upon the needs of a specific producer. It just is the case that
and you have to,
and you have.
Yeah, and the thing is, I had a writer who pretty much, sometimes people just shoot themselves in the foot. I had a writer who had his property optioned by Universal, by a big producing team, and he refused to do the rewrite they wanted.
Why didn't they just hire somebody else to do it for him, or did they?
They didn't want to do that
because
he dug his heels in so badly.
They were mad by
They essentially said, "Screw you! We're not going to help you have a career.
Yeah,
you should not be working."
Yeah,
and they paid him. And they paid him to do the rewrite on his own screenplay.
Yeah,
it's not like he was doing it for free. And they just said, "Forget you." And he had an agent at who was he? UTA at the time. And it just didn't make any sense. And that was just somebody who decided that he would rather be right than be happy. And he gave up his entire writing career over it.
I don't know. I've met a lot of people that have done that. I've met a lot of people who are great writers that, when push comes to shove, they cannot handle the aspect of the industry. It's a very collaborative industry, and you have to do it for it.
Well, you know what? Here's what I tell writers: if you don't want to collaborate, go become a playwright.
Right. It's true. I tell people that too. I go, listen, you can be an author, or you can be a writer producer. Tarantino, I don't imagine he's a good rewriter at all. He's a very good writer, but I doubt that he's the kind of person you're going to hire to rewrite things. he doesn't work and play well with others.
Yeah. But even as a writer producer, guess what? The director's going to step in and they're going to do whatever they want.
Yeah, exactly. No, that's true. And the thing is that the director probably, will force you to make changes based upon the stuff that they need to have in the screenplay, and you're going to have to write stuff for actors. But it is definitely true. I've told people the same thing. It's like, maybe being a screenwriter is not for you, because because you have to actually enjoy the part where somebody comes in and goes, "What if the lead's a girl?" You go, "But I wrote it as a boy."
Exactly.
I just can't see that. No, it's definitely true. Are most of the people that you work with WGA members, or do you work with both WGA and not WGA?
Both. I have both clients that are WGA members and clients who are not. A lot of clients, because there is, in the world of independent film, is so huge, and most independent production companies don't want to become WGA members. They, a deal becomes substantially more expensive once you're dealing with people that are union members.
Well,
that a lot of production companies, if they can find what they want and their writers are not WGA members, they'll go that route.
Well, I think
So,
working with either you working with the working with the WGA, the Teamsters and SAG. I mean, that's a relationship. You know,
oh
there's
yeah,
going to be a lot
well, it's
going
worse.
on.
Yeah, it's worse than a relationship because they'll shut you down.
Mhm.
Yeah, I mean, right away, the minute you go and work with a union, right away, pension and health, 15% on top, more expensive, right on top.
Right.
And then, you've got the minimums where
Mhm.
when you're dealing with a union, you're dealing with those minimums. And then above and beyond that, residuals. So when a film is in distribution, the residuals get paid from $1.
Right.
So you could be paying a union residuals before your investors have even broken even.
Oh, you will be.
Yeah, and the thing is that most often the difference between an investor breaking even and not breaking even could be those residuals.
Exactly. Have you do you actually work with writers? Sorry, do you work with writer producers and filmmakers as well to help build the contracts they need in order to produce their projects?
Yes, I do. I do production legal.
Hmm.
So I do everything that you think an entertainment attorney would do except litigate.
Really?
Because that's really not an entertainment attorney. That's really a litigator.
Hmm.
So I don't do securities law because
Hmm.
that's not something really entertainment attorneys do.
Hmm.
But I work with writers, producers, directors, actors, and in terms of producers and writers, I work with them from day one. So if
Hmm.
I have a producer who is optioning material, I draft the option agreement for them. I negotiate it.
Hmm.
I do everything I do for the writer, but on the producer side. And then
Hmm.
once the film, goes into production, I do production legal.
Right. And when you mentioned that you don't do securities law, but do you have recommendations where if people need to get a private placement memorandum or need help doing the Form C for a Regulation CF campaign? Do you
Yes.
have people that you refer to
Yeah,
for that?
I have an attorney that I usually refer people to because I've been referring people to him since I was in law school.
Mm-hmm.
And I find that he's the least expensive securities attorney I've run across.
Great.
Number one. Number two, that's all he does.
Mm-hmm.
And that's what he knows very well.
Mm-hmm.
And lastly, he will split his fee in half and
Mm-hmm.
charge half of it up front and the other half when the filmmaker has raised the money.
That's really smart. I mean, it's very helpful to because that putting together that first amount of money in order to put together a private placement memorandum is something that stops a lot of projects from going forward. Even when people have investors, it's just daunting, and they
Well,
also need
the other
advice.
thing, yeah,
You
but
know,
the other thing that he does as well is he works on a sliding scale.
that's excellent.
So if you're raising, $500,000, you're not going to pay the same as if you're raising $3 million.
Right, because it's the different sets of agreements, and it's less complicated.
No, it's really not. But
Mm-hmm.
he tries to accommodate everybody.
Well, that's really nice of him. Well, I'll be sending people to you, and so you could refer them to them.
Yeah,
That's
for sure, for
you
sure.
know.
Yeah, I mean, I find that why are you going to spend $40,000 on
Mm-hmm.
all your paperwork when you could probably do it for less than 10 with him?
Well, I'll tell you what's interesting is about 50% of the people that are in my groups are producers, which is to say, and some of them do projects, from 100K, and some people do projects that are heading up to 2, 3, 5 million. So across that wide spectrum, the number of people who find themselves needing a securities attorney is pretty broad. I mean, it's just the
Right.
nature of the beast.
Well, yeah, you have to do it. And the one thing that I'll tell people,
Mm-hmm.
because everybody always asks me this question, is about finder's fees.
Mm-hmm.
It is against the law to pay for a finder's fee.
Yeah, I'm always telling people that too. It's shocking how few people believe you, isn't it?
I know. I always love. My favorite question is when they say, "But what if?" or "Even if this," and I say, "Yeah, it doesn't. Forget the even if."
Yeah.
The bottom line is it's a very black and white rule. Normally, let me just explain something. Securities are stocks and bonds, just like your stock you could buy in the New York Stock Exchange. Okay?
Mm-hmm.
So anytime you sell an investment, you're selling a security.
Mm-hmm.
And so after the Great Depression and the stock market crash,
Mm-hmm.
our government decided that they needed to do something to avoid that ever happening again.
Mm-hmm.
And so they put all these regulations in place.
Mm-hmm.
So securities law is very black and white. There is no gray.
Mhm.
So when I say to somebody, you cannot pay anyone a finder's fee to introduce you to investors,
Mhm.
you really cannot pay anybody a finder's fee to introduce you to investors. Now, I know that a lot of people have run across people that call themselves finders,
Mhm.
and that they may have paid a finder's fee in the past or know people that pay finder's fees. You're still breaking the law.
Mhm.
And if FINRA, which is the agency that oversees all of this,
Mhm.
finds out about it, and I'll tell you in a minute how they find out about it. If they find out about it and they find out that you paid finder's fees, they will make you return all of the money that you raised, even if you already spent it.
Mhm.
So you really don't want to be in that position.
Mhm.
And what was I going to say that I was going to explain?
You were going to talk about you were talking about finder's fees and about the having to return all the money, and you were going to tell us how FINRA finds out that people.
Oh, the way they find out about it is because you get sued.
Mhm.
You know, if your film loses money and you made the mistake of putting projections in your business plan, which I don't recommend,
Mhm.
because normally when people put projections in their business plan, the example films that they use
Mhm.
are films that were all big hits. They
Mhm.
never put in as many losers as they do winners, right?
Mhm.
So you may have investors who thought that this was a sure thing.
Mhm.
And if they lose their money, they're going to turn around and sue you. And guess what the lawyer's going to look for?
Mhm.
Anything and everything that you did that you shouldn't have done.
Mhm.
And if there was a finder, they're going to look and see if you paid finder's fees.
Mhm.
And that lawsuit will lead FINRA to you.
Mhm.
And you don't want to be in that position.
Well, the other thing about it is my experience with finders is that they don't always bring you the. You need to have accredited investors. Need to have investors that meet certain standards. That's not usually what finders bring you. The other
Well,
thing is
no,
there's also a
they
thing
don't.
called a dealer broker that you know. It's like there's people that do this job professionally and for a living, and that are SEC, that meet
Right, they're
SEC
usually working at
qualifications.
they're usually working at a stock brokerage firm. That's what a broker
Right.
dealer is.
Right.
Somebody working at a stock brokerage firm.
Right.
But my biggest problem with finders
Mhm.
is that aside from the fact that it's against the law, many of them want a fee up front.
Mhm.
Run for the hills of anybody that asks you for money up front.
Mhm.
Okay, because they're not making their money being productive. They're making their money off the fees that they get up front.
Mhm.
So if they got 50 people, each of which pays them pays them $5,000, there you go.
Mhm.
They've made $250,000 in a year for saying they're a finder and not really having investors that actually invest in films.
Exactly. Well, I'll tell you what. I think we should check to see if people have any questions, because
Okay.
covered we've covered a lot of information that people need to know. And is there anything else you think before we open the floor for questions?
No, why don't you go ahead and open it for questions?
All right, great. So if you guys have any questions that you'd like to get answered, please send me an email at nancy.fulton@yahoo.com. That's nancy.fulton@yahoo.com. And I'll go ahead and I'll make sure it gets asked. So we have one from someone who says, is there an amount of time after a person's death that would make it no longer necessary to get life rights from their family or friends? For example, somebody like Wild Bill Hickok, who died in 1876.
Well, it depends on whether anybody inherited his right of publicity.
Mm-hmm.
I would say that you're probably safe
Mm-hmm.
in proceeding without that, but it's always best to consult with an attorney and just have the attorney, whether it's me or somebody else, look into it and see who their heirs are and whether they have been exercising their rights.
Mm-hmm. And is it okay if information about their life story is derived from newspapers? I think you mentioned that you can't just read any book and then take whatever it says in a given book and turn that into your screenplay, because the author of the book of a historical book will have made inferences, and if you're
right, first of all, finding something in a book and finding something in a newspaper are two different things.
Mm-hmm.
because remember how I said that history is not copyrightable?
Mhm.
So arguably, something that you read in a newspaper is history.
Mhm.
So you can't take an article about something that's really unique out of let's say Rolling Stone magazine and use it, because that person did a lot of research, and it's just a unique thing. But if somebody is reporting on a trial or reporting on a crime that they witnessed, you can write about that.
That's very cool. If somebody is writing a life story about somebody like William Colgate, the founder of Colgate, who died in 1857, is it necessary to get rights from the Colgate Company?
Well, and here's the thing: it's important to see where the person died and what the right of publicity is, because in most cases, the right of publicity is going to last less than 100 years. So once you know where the person died, the attorney can look and see, they can go ahead and look and see whether the estate has any rights anymore.
That's
the one thing that I always tell people to be careful of. Now you're dealing with something like a company. You have to be careful not to put anything out there that's defamatory against the company.
That makes total sense. I 100% agree. I think people have to be very careful.
Although William Colgate is dead, if you say, well, he developed this poison that goes into the toothpaste and they're still using it, now you've got a problem. Right,
because that's quite the allegation.
Right.
So somebody else asks about transmedia franchise differences, which he says, where you will be selling or pitching only a partial segment of a whole concept while explaining the benefits of being the pioneering part of a whole. So I think that means he's got an idea, sort of like Teenage Mutant Ninja Turtles, where he's saying, "Look, you do the film, and then there's all these other opportunities for making toys and so forth."
I will tell you. I don't know what exactly. I just want to make sure that I'm getting your question correctly. So if I don't have it correctly, write Nancy back, okay? So these days, studios acquire all the rights. So if I come up with an animation concept for, let's say I was the originator of Teenage Mutant Ninja Turtles and we were doing it now, the studio is going to want the motion picture rights, the television rights, the merchandising rights, the book rights, the stage rights, the theme park rights. They're going to want everything. And the way that they normally do the deals with writers is that they will pay you for the initial exploitation. And if it goes to television, you will get passive royalties, or if you end up writing on the show, you'll actually get paid to be a writer or a producer on the show. But in terms of merchandising and things of that nature, all that other stuff gets thrown into the pot for profit participation.
Right. That makes sense. So it seems like it's very much a the kind of, if you want to, the more complex the deal gets, the more important it is to have an attorney involved, particularly for something like that. If you're bringing something that's very complex.
You can't negotiate your own deals.
Yeah.
Never negotiate your own deals. I always say to people, when you think you can't afford an attorney, you can't afford not to have one. You really need somebody who can play hardball for you. And if you try to play hardball yourself, first of all, you're going to leave things on the table that you don't know to negotiate for. But more importantly, they're going to think you're a really difficult person. And you'd rather they think your attorney is a bitch than they think you're a difficult person that they don't want to work with.
I do agree with that. That is very true. It's amazing how perfectly normal people, when they have to talk about money, they get mad when they have to talk about it. And it's like, even though it's just a necessary part of doing business, they get all cranky. So it's nice to have somebody else do it for you.
Yeah. No, and it's not even about getting cranky. It's about being a tough negotiator. Like, it's perfectly acceptable for your lawyer to be a tough negotiator. But if you're a tough negotiator, they may just think you're just too difficult to work with, and they don't want to work with you because they think that you're going to be that way in the writer's room.
Yes, that's true. That's very good advice. We have one last question. Someone asked, Dinah mentioned that managers are more likely to develop new writers than, say, agents. Is this true for attorneys as well? So I think it's a kind of a quick way of asking, do you help develop writers or help writers develop their careers?
Well, yes and no. I do not take on new writers on a percentage basis because 5% of zero is zero. And I can't, I'm a self-employed person. I don't have a big law firm paying my salary. So every minute that I work, I have to be able to account for it and have a legal fee. So if a deal is on the table and that deal is going to pay my writer enough so that my 5% will equal my legal fee, fine, I'll do it for 5%. But otherwise, my hourly is $400 an hour.
Okay, that makes really good sense.
Yeah, and then I do have a portion of my client base that are new up and coming writers who are just breaking into the industry. They're doing their first deal. I don't have a problem with that, but I caution people against thinking that their lawyer is going to make their career.
Yes, or anybody else, frankly.
So, yeah. But like I have a lot of people who contact me who think I'm going to get their movie made. It's your job to get your movie made. Yes. It's not my job to get it. To find you the producer and the money and all of that. You have to do the footwork.
So interestingly, we have another question coming in that I think you'll find which has two parts, which I think you'll find very interesting, and it's called "How to Protect Yourself in a Writing Group." So the first question is: at what point does a film become public domain because they want to make a film or rewrite a film that was made in 1941?
Okay, well then, they can't. First of all, before you go to the next part, so it's not going to be in the public domain. Right now, things that are in the public domain predate 1923. So that film is not in the public domain. So I was going to bring this up, and then I thought, let me not bring it up. We have a limited amount of time. Okay, so every once in a while, I will get somebody who contacts me because they want to remake a movie or they want to remake a television show. Forget about it. Don't waste your time. The studio will never give you the right to remake their property. They don't like to give up their library assets, and I will tell you that I've been down this road a number of times on behalf of writers. They will just never give it to you unless you have a studio deal or you are a director that they want to work with. They want to be in bed with Guillermo del Toro, and Guillermo del Toro says, "I want to remake blah blah blah." Then they'll say, "Okay, come and make the movie with us." But for somebody who is not at that level, you're wasting your time. And don't write it and then think, "Oh, I'll write it and I'll go show it to them and they'll think it's so wonderful." No, they won't even read it.
Actually, they'll be mad you wrote it.
Well, yeah, it's copyright infringement, but they won't even read it. Some guy did a version of Rocky. And I think it was Rocky 3 or Rocky 4. And he sued MGM because he showed the script to MGM, and somehow the Dolph Lundgren character showed up in the movie. And there was a similar character in the script, and he sued MGM, and he lost because the judge said, "Well, you infringed copyright. You had no right to write that script," and the writer lost.
Wow, that's awesome.
So just go find something else to write. I know you're passionate about that movie. It's not going to be in the public domain for at least 20 years. So, just for the heck of it, go and do a copyright search and see if the copyright is still valid. But in all likelihood, it won't be in the public domain for 20 years, and don't waste your time.
Right. The next question is kind of, I think, more interesting because I always wonder about it as well. I recently pitched a concept at a writers group. 1 year later, I hear that the leader of the group sold a series to Amazon that favors my pitch. What are my options, and how do I protect myself from this happening again?
Well, I would say that the writers group should have an agreement. They should have all the members sign a non-disclosure, non-circumvention agreement that essentially says that they can't steal each other's ideas, and that if they do, that the person who wrote the original idea will automatically be attached to the project.
Yes.
And that's something an attorney can draft.
I think writers groups are an interesting thing because everybody gets to know everybody else's screenplay, kind of inside out, you know.
Yeah, and the problem is that writers group cannot work if writers can't trust each other. Right. So I think a good way to make sure that everybody feels like they can trust each other is that they know that there's an agreement in place that everybody signed.
Right. If somebody wants to adapt a book or a novella or some other intellectual property created by a friend or a family member, and they get permission from that person, do they still need to purchase those rights, or is it the case that can somebody give you those rights?
Yeah, you don't have to. Look, I would say you at least need to purchase it for $1 because there has to be consideration for every contract. But beyond that, if somebody wants to give you a property, woohoo, lucky you.
That is really a great idea. That is actually, I mean, I think people a lot of times don't realize that every contract requires consideration. So if you don't have consideration, it's a problem.
And you still need a purchase agreement because you still need to acquire rights in writing. But if they're willing, you may want to give them enough money so that if they feel like they need to hire an attorney, they can. But if not, if they don't want to hire an attorney and they just want to sign this agreement,
I think that totally makes sense.
They can give it to you if they want to.
Okay, cool. That's excellent to hear. And then let's see. And then I guess the final question is, just because I think it's relevant. Someone says that now there's a lot of hours, with people like Netflix and iTunes and everybody, Hulu producing property. So it seems like there's not a limit to the amount of time for television. And yet, so is it still the case that TV is hard to sell into? I mean,
yes.
As you were describing?
It still is. Number one, because there's a limit as to the amount of money that's available. Number one. Number two, do you really think that Netflix is going to give a first-time producer $5 million to produce a season of a show and they've never produced anything?
That's true. Right. So it's also a matter of experience as well.
Yeah. I mean, everybody wants an executive producer that they trust, that they know is going to deliver the project on time, on budget, and at the level of quality that they expect and need.
I agree.
And you only get there with experience.
I agree. And I think one of the reasons I believe that I know a lot of people are becoming writer producers, and one time I actually went up on IMDb and took a look at everything that's being produced for under $1 million. It was all writer producers or actor producers, like really 90%. And that was true all the way up to $3 million.
Yeah.
And the reason that that's the case is because that's the only way that they can guarantee that their stuff's going to get made.
That's what I was going to say. If you really want your property to get made, you have a screenplay. Don't wait for somebody to say yes to you. Go out and figure out how you're going to get it done.
And I think the future is going to be populated by I mean, if you look back at people like George Lucas, or look at Quentin Tarantino and look at all those guys, they did have screenplays, and they went ahead and turned them into intellectual property, and they built their career based upon the projects that they put together. And in a sense, they bought their own ticket into the industry.
Yeah. Look, I have a client who in 2016 had what was considered one of the top 25 films of the year in terms of quality, a little movie called The Love Witch. And James Franco reviewed it, and he thought it was awesome. And if you look at the credits on that film, she directed it, she wrote it, she produced it, she made the costumes, she went out and she raised the money for it.
Wow.
And this past year, I have a client who'd never made a film before, and he decided he wanted to be in the film business, and he made his first horror film. He made it for under $500,000. You would never know it by looking at it, and got distribution right away.
No, I think it's more and more common, and you can do a lot with $500K now.
And the thing is, because now the technology is such that you don't get automatically shut out by not having millions of dollars to make a movie. So if you really want to get your movie made, and let's say you shop it around for 6 months and you don't get any bites, then figure out how you're going to find somebody who knows how to do a budget and attach a producer. It doesn't have to be a producer with a huge track record, but somebody who knows how to do a budget, maybe went to film school and has made short films and knows the ins and outs, but maybe they've never made a feature. And then go out and do what you have to do to raise the money.
Mm-hmm. Well, and actually, one of the things I cover in a lot of my events is how to produce a film, and with the word, going from budgets and shooting schedules all the way through the development process, So and I bring on line producers and so forth to talk about those kinds of things. But I think it's definitely the case that it's very hard to break into sort of the studio system, whether for features or for television, without having credits. Just as you say, they're looking for a track record.
They are looking for a track record, and you can't be part of the club until you've had a success.
Mm-hmm.
So if you really want to break in and you're having trouble, go and write a film that can be made for under $1 million, mm-hmm. and then go and make it.
Exactly. Well, we've taken up so much of your time, and this group could keep you answering questions for literally the next few days. But I'd like to take a moment to say thank you very much for coming on the call and for providing such useful information. And do you want to go ahead and review how people can reach out to you if they would like to? Also, one other thing before we go, you mentioned the fact that you're actually fully bilingual, so you're a particularly good contact. You're a great contact for writers and filmmakers across the board, but you're particularly good if somebody happens to be producing content for Spanish-speaking communities worldwide, or wants to work. I would imagine you're pretty good at negotiating deals for helping people negotiate deals for Spanish distribution in countries like, say, Spain or Mexico, Central or South America.
Right. Yeah. Yeah, I speak Spanish, I read Spanish, I write Spanish. I don't draft in Spanish because, quite honestly, most of the time I get Spanish-speaking clients who come to me because they're doing business in the U.S. Mm-hmm. or because they're doing business in their country but with a U.S. company. Mm-hmm. So, but yeah, I'm fully bilingual. Bilingual. And anybody who wants to get in touch with me, you can email me at dinahperezlaw@gmail.com. Mm-hmm. That's DINAHPEREZLAW@gmail.com. Or you can phone me at 323-935-7955. Mm-hmm. I'm happy to talk with you and see what you need and see how I can help you.
Great. Well, and what I'll do, with your permission, is I'll go ahead and download this recording after it's finished, edit it up so it's nice and clean, and then I'll send it over to you for review. And then if you approve its release, we'll go ahead and we'll make it available to the people that were on this call. And with your permission, I'll make it available to other people going forward who happen to join my group. I'll make it available. Fine. I'll promote it widely, I should say.
Yes, that would be fine.
Oh, you're so wonderful. Thank you very much. I very much enjoyed this call. It was truly wonderful. You've been a pleasure.
My pleasure. It was fun.
Great. I hope you have an excellent evening.
Okay, you too. Bye-bye.
Goodbye, everyone. I hope you had a nice call. And remember, you can always send me, if you have questions about anything, you can send me an email at nancy.fulton@yahoo.com. I look forward to being of service to you.